One. Yeah. Okay, we're live.
All right. Welcome everybody to the Civil Law and Procedure Subcommittee on March the 18th at 12:30. Thank you for being here. Okay, so we're going to start. We only have I believe we only have two bills to discuss today. And then if anybody wants to bring up any other issues, we can talk about them. The first bill I wanted to talk about was House Bill 308, the SLAPP bill. I was inclined, as I had already mentioned, because I am very interested in seeing something go, I was inclined to make a motion to reconsider the vote by which this was taken, as it was a 4-4 vote, and being on the prevailing side, I am permitted to do that. Even though we don't actually have official rules in subcommittee, but I was going to allow that since it works, and change my vote, because as you know, I am very interested in seeing this, and I want to see this or something go through, and I would be the deciding vote. Hold on one second, Delegate Conaway. However, some of you may have noted an email that we received from Rebecca Snyder, I believe yesterday afternoon or evening. And that email really, really pissed me off, to be perfectly frank. You don't objectify the chairman of the committee that subcommittee that handles your bill and tell him that he's wrong, and actually be wrong on the law, which she is, and expect everybody to vote in favor of it. That being said, I try not to take things personally, and I will deal with that at a later time. What I did want to do is review with everybody very quickly one additional issue on this bill, and then we'll move on to the next bill, and then maybe take a vote and then move on to the next bill. So does anybody have a question about what SLAPP suits do and don't do? Delegate Watson, do you understand the concept behind SLAPP suits? I just want to make sure that we're all on the same page before.
And I appreciate that, Delegate Cardin. Can you just run it down one more time?
Sure, I'd be happy to, because sometimes I get confused too. A SLAPP suit is basically a lawsuit that is filed, and if it is determined to be a SLAPP suit, it is filed with the intention to silence or delay the ability for the defendant to be able to voice his opinion on something.
Okay.
If I am, this easy example is, there's a guy who's building a housing development in my backyard, which there happens to be, and I go and I start going to the zoning commission and tell them that they're violating all these zoning laws or doing all these other things that I think are wrong, to try and stop him from doing what I think is wrong. And that developer then files a lawsuit against me. And the intent of the lawsuit is to just get me to stop talking. If what I am doing is legitimately for the public good, essentially, or a court determines is for the public good. So that's what the SLAPP suit would be. And I would then, if I am the defendant, because that person filed a lawsuit against me to bankrupt me or stop me from talking, I then, the point of this legislation is to allow me to file a motion to dismiss the suit, get discovery, prove to a judge that what he did was a SLAPP suit, so that the case can be dismissed. And that is essentially what the bill does. I mean, there's a little bit more broad concepts, but that's the idea behind it. Any other are there questions about that and what a SLAPP suit does, or Delegate Grammer and Delegate Conaway? I know you had a question too. So very quickly, and then I want to get into a potential discussion before we take a vote. Yes, Delegate Grammer.
Two things briefly. I just wanted to speak up for Ms. Snyder. I'm sure she meant no offense, and I'm sure she's just very enthusiastic. Second, I don't personally object to the intent of the bill. I just personally need more time to work out a couple details for myself. I understand if we take a vote now, I understand, but I'm very close to being a yes, but right now I'm still a no.
Okay, thank you. Delegate Conaway, did you have a question?
Yes, one, Mr. Chairman, thank you very much. Can you send me a copy of the email that you,
I did. I sent a copy of the email that Rebecca Snyder.
and so now you're thinking about changing your vote to,
I voted against the bill the last time, and I am making a motion to reconsider the vote by which it failed because I am considering changing my vote to a yay.
I would second that motion. Thank you, sir.
All right, good. Okay, excellent. Now, let me tell you, so one of the issues that we have talked about briefly, and I just wanted to bring it up, is the fee shifting. In fact, Ms. Snyder talked about it a little bit before, and basically saying that if I as a defendant in that example, win my motion, the judge dismisses the case because he considers it a slap suit. The question is, do I then get my attorney's fees and costs paid by the plaintiff because they put me through this? Or the other way is, if the plaintiff wins, does the defendant get to have to pay for the costs of the suit and the attorney's fees? So yes, Mr. Watson.
Thank you. I had my hand up a little bit ago. So that last part you're talking about, is that where we got into the discussion of whether the bad faith language had to be in there or not?
So no, it is not, but it will come back. That will come back in a second. But the bad faith, so going back to the bad faith. So in Maryland, the statute, we have a statute that allows for these kinds of, allows for a judge to dismiss a case based on the SLAP statute. But the defendant has to prove that the plaintiff filed the lawsuit with bad faith, which is apparently a very high standard to prove. It's very difficult to prove. And so these cases don't necessarily get dismissed. Now, a defendant may in the end win a year down the road, but they would, in theory, bankrupt the defendant before he would have a chance to win. And the plaintiff would get to, because it happened a year later, he's already built his housing development. So the point is moot anyway. So the question is whether you should have to prove bad faith or just say that he can't silence me. It's my First Amendment right. And therefore, it doesn't matter whether he's doing it in bad faith or he's just doing it because he's just a bad person, or a person who doesn't like anybody getting in his way and he's trying to silence them. And that's what the advocates for the bill want. They don't want to have bad faith in there. They want to have you be able to file a motion to dismiss without having to prove bad faith. Okay. I have done some research. Actually, I should give kudos to my legislative aide, Andrew, who's on this call, and his staff of 3 amazing interns, 1 high school and 2 college interns, who in the last hour and a half went and found all the information from the 27 other states that have SLAP statutes. I don't know if, Andrew, I don't know if we can share that or send that. Can we send that document to the?
Yeah, let me download it as a Word document and then I can share that.
Okay. And basically what I asked them to do is find out what the fee shifting rules are in the other 27 states. And what it looks like to me is most of them, about 20, 22 or so, have the fee shifting as a requirement. So if the plaintiff wins, then the plaintiff gets costs and fees. If the defendant wins, the defendant gets costs and fees. Some of them, actually many of them, it's only the defendant that gets the fees if the defendant wins, but not necessarily the plaintiff. More than that, though, it's fee shifting both directions. I happen to like the language from Oklahoma as a consideration for us to take on. Oklahoma does require fee shifting, but gives the judge discretion to choose that it's appropriate for justice to be served. So I want to make sure I share that language. and see if that's the language perhaps we can offer, which against my ego and pride, but in favor of doing what I believe is correct, I am going to offer that that language because I think that that my personal feelings about that ridiculous attack on me, I wouldn't call it an attack, that ridiculous comments made should not interfere with making good policy. All right. So I can answer while, oh, it looks like Andrew is sharing the Google Doc in our chat, and Delegate Conaway, question.
Thank you, Mr. Chairman. So now you're talking about fee shifting, what fee to who?
Okay, so if you look at the Google Doc,
You mind just telling me?
I'm going to read the language so that it's clear. Let me just see if I can find it. I want to make sure it's okay. If we go to Oklahoma, if the trial judge grants the anti-SLAPP motion, in other words, dismisses the case, the court must award attorney's fees and costs to the moving party, but only if the court determines that justice and equity require it. The court may also sanction the party who brought the SLAPP suit as the court determines sufficient to deter the party who brought the legal action from bringing similar actions. However, if the trial court finds that the motion to dismiss is frivolous or solely intended to delay, the court may award costs and reasonable attorney's fees to the responding party. So it basically goes both ways, is the way I read it. I just thought I liked that language. Any comments on that? I'm going to come back now to, yes, Delegate Williams first.
Thank you, Mr. Chair. I guess I had a comment and a question. So I was looking at what's in the Google Doc as it relates to Oklahoma, and I do see the language there. I guess the one thing I also saw, oh God, now I feel like I need to try to find it again. What did I just do with the text? Okay, let me just click on it again. With the Oklahoma one, it also talked about that the judge may award sanctions. So right. I wasn't certain if you wanted to also include that.
Right. I don't think we should get into sanctions because I think that's a whole nother. I think we would just deal with the fee shifting.
Okay.
So I said that, but then I realized after I said it that. So this is for the purpose of Holly. Holly, if we're gonna do that amendment in concept, we do not want to deal with sanctions.
Okay. And then the other thing I noticed, Mr. Chair, sorry, I guess this is my comment question. So I'm looking at some of the surrounding jurisdictions, Virginia, the District of Columbia, Pennsylvania, all actually have kind of mandatory attorney's fees costs for whoever wins the suit. I'm looking at Pennsylvania, which says if you prevail on your motion under the Pennsylvania anti-SLAPP statute, the court will dismiss the lawsuit against you and you'll be entitled to recover your attorney's fees and court costs. And if you are only partially successful, the court may award you either full or partial fees or costs at its discretion. And so I was wondering, like, why going with Oklahoma versus—
I thought that Oklahoma, right. That's a great question. I was looking at the different language. I mean, again, this was all put together very quickly by my staff, and they did an amazing job. But I'll get you in a second, Delegate Conaway. But I agree that I was just looking at, I thought Oklahoma's was good. I mean, Pennsylvania's is okay. I personally believe that discretion is appropriate because judges, each suit is going to have a unique flavor to it, and a judge can have that. So I figured it seemed like Oklahoma requires it, but then gives the judge the discretion to determine both how much and what's appropriate in the interest of justice. So to me, that seems to be kind of a fair way of doing it. That's my perspective. I understand. I'm not sure exactly how you win partial. Do you either win?
This
the
is
motion
if
to
you
dismiss-
if you win the partial portion of the suit. And I don't know, I guess that would be really, I guess for the trier of fact.
And to me, that would seem like that's why, you shall win. I mean, it is mandatory, but the judge then can determine, do you get the full amount? Do you get partial? Did you win the whole thing? Did you not? So to me, it seems like Oklahoma gives enough latitude to be able to do what's right in that case. That's why I chose that language. But any other comments? So yes, Delegate Conaway. I mean, I don't have anything personally I don't particularly love Oklahoma, although I do think Tulsa is a really great city. So, but I just think that language just seemed to be fair, very fair and appropriate.
Thank you, Mr. Chairman. To Mr. Stover, would he mind sending that information to my laptop?
Yes, I can do that.
My administrative assistant gets lunch, so I'm sorry.
Okay, I can
Some
do
of you
that.
guys don't.
Thank you. Thank you very much. All right, is there any other comments? Is there, can we do a motion just on well, first of all, there was a motion and a second on to reconsider the vote by which the original bill failed 4-4. Can I have a vote to reconsider? All those interested in reconsidering, raise your hands. 1, 2, 3, 4, 5, 6. Okay, everybody. So everybody's willing to reconsider. Thank you very much. Okay. Now on this amendment, although we don't have the actual language drafted, Holly, do you think you can draft the language? Because it would be and would replace the highlighted version that you had sent me about attorney's fees.
Yep, I can do that. And I'll just plug this language in, minus the sanctions.
Minus the sanctions. And I
Yeah.
think that is, I'm going to tell you, I think that's technical enough. And if we need to make any changes to it, we can always do it in the Senate and then come back to concur. Okay. Can I have a motion on the amendment? Okay. Any second?
Second.
Great. All those in favor of the fee shifting language, raise your hands. 1, 2, 3, 4, 5. Any opposed? Okay, good. Okay,
I was trying to vote for. I'm sorry.
that's
I got
fine.
lost.
That's fine. We got enough. We're not recording these votes. So
Okay, well, just put me
for the record and for posterity, delegates voted in favor of the amendments, everyone. Okay. Now on the bill as amended, I think we've basically done everything that Delegate Rosenberg has asked us to do. And I'm assuming I'm going to get flowers on my desk at some point later. I will take a motion on the bill.
Move to accept the bill as amendment.
Second.
Okay, and I understand, Delegate Grammer, if you want to explain your vote, you can, but all those in favor of the bill as amended, raise your hands. 1, 2, 3, 4, 5, 6. And all those opposed? Okay, very good. So the motion passes. Great. Now let's go into House Bill 23. Holly, do you want to explain it? Let me try and explain it.
So Andrew has a reprint, so let's bring that up.
Okay,
And we can go
Yep.
from there just to make sure everybody can see it and you can lay out exactly what we're going to strike. Andrew, do you have that?
first of all,
Yes.
Frank, if you want to talk more or you want to go over that language, we can do that later and make sure that you're good with it.
I'm fine. Thank you, sir. Thank you, Mr. Chairman.
House Bill 23 is Dana Stein's bill on sharing information with ICE, if you guys will remember. So I believe, Holly, have we already passed the bill?
So we did, and we had a little bit of a hang up, and now everybody's on the same page, but Andrew, go all the way down to the bottom.
Okay, so we have already passed this bill, but
We're gonna strike, we already, we passed
let me-
it.
let
Go
me
ahead and
try
give
and
some background.
Right, let me just explain. So we already passed this bill. However, after we passed it, we got a call from a couple of different agencies saying they were concerned with the language. One of which was the port, which didn't realize that we had struck the port out of the bill. So after we explained that to them and they read the new reprint, they were okay. Then we got an issue with Department of Corrections wanting to dated letter from the AG, making sure it was constitutional. Delegate Stein had requested that letter, had then sent that letter to Department of Corrections, showing that it was in fact okay, and that they are permitted to do this. And so they then were okay until they realized Section D all the way at the bottom that you can read. Maybe Andrew, you can make it a little bit bigger for my old eyes. But Section D, Department of Corrections had a real problem with. And in fact, in the bill on the Senate side, in the cross-file on the Senate side, that language was either struck or never made it in, and they were requesting it to be deleted. We then checked with the sponsor and with the AG and everybody else, and everybody seems to be okay with striking that language, which takes the opposition from Department of Corrections out. So there is no agency opposition to this legislation with striking Section D of the delineated copy. Is that fair to say, Holly?
Yep, that's perfect.
Okay. I got to make sure I know this in case I have to say it again.
No, that was perfect.
Okay. All that being said, I wanted to ask for so we're bringing this back for consideration of a committee amendment. And I wanted a motion on the amendment. And again, what the amendment does is it puts Department of Corrections not in a no opposition mode. I don't think they're going to write a letter of support, but they're not opposed.
Can you, I'm sorry, Delegate, Mr. Chair.
Sure.
Can you explain what it does again?
Okay, so what the language that was stuck in there, this language Section D, was sort of a umbrella that basically, it was sort of the bill in miniature. It does what the bill is attempting to do, but in a second redundant passage. The department was concerned that while they can perform the actions required in the bill, that this could create unnecessary confusion and possible conflict. So
Okay.
the sponsor of the bill and staff, both staff in HGO, in ENT and staff in judiciary, both believe that the bill is still satisfactory and accomplishes what it's trying to do without Section D. So what we're doing is we're deleting this section that says, notwithstanding any other provisions of the title, an officer, an employee, an agent, a contractor of the state may not disclose public records essentially without a warrant. And
That's good.
that's essentially what the bill is trying to do, but it's.
Okay.
It's
Thank you for working the
definitely
kinks out
language.
on this bill, this important bill. Thank you.
Yep. All right. So is there a motion to accept the amendment?
So move.
Okay, is there a second? So this amendment, is there a second? Can I have a second? Or is there no second?
Second, sorry, I was having
Thank you.
problems
Okay.
unmuting, Mr. Chair.
I will generally say in conversation, discussion, this amendment makes this bill easier to swallow for those who might be opposed, even if you're going to vote against the bill. Just FYI. All right, all those in favor of, okay, Andrew, you can take it down. All those in favor of the amendment, raise your hand. 1, 2, 3, 4, 5.
Oh, where did Rachel go?
6. So we have 6 in favor and 7 in favor, I think. There's no opposed. Good. All
At a
right.
meeting, she had to hop on too.
I understand that there is that this is not necessarily a partisan bill, not a partisan bill, but I believe that it's a good priority for us as in the state. So I'm gonna ask for a motion favorable. Is there a motion?
Move favorable as amended.
Okay. And is there a second?
Second.
Great. Does anybody want to have a discussion before we vote? All right, great. All those in favor of the motion, favorable, raise your hands. 1, 2, 3, 4, 5. Okay, and any opposed? 2 opposed. Note that in case they want to say they fought like a tiger, Delegate Malone and Delegate Grammer were both opposed.
They did. I even got a little scratch. Fought really hard.
We may still have 766 come back. We're not sure. We're working on and talking with folks to see if it's something that we want to do.
Mr. Chair, what was the bill number of that bill?
That bill was 23.
23. Okay, thanks.
That one's a joint one
766.
with ENT.
Okay,
Jointly assigned with ENT. 766 is the bill that changes the fee schedule for estates. And again, we're going to hold it because we have some amendments. I'm still talking to the sponsor about whether we're going to bring it or not. So we're working on it. I am also working with the chair on 213, which I believe is a bill for the small guy that I'm trying to get out. I hope that's an indemnity for engineers and architects. Primarily, it assists minority and women-owned businesses. And for some reason, the Attorney General and I don't seem to see eye to eye, but we're working on it.
And
I
Delegate
don't
Carter, are we
understand why
going
he's
to
opposed.
touch on 405?
Oh yes, I'm sorry. We do have a third bill, 405, very quickly.
Mr. Chair, is this the bill with the property thing?
No, 405 is the bill for fee shifting for children in special education.
Okay, I was wondering if we were addressing that. I think it's Delegate Teresa's bill at some point.
Right, I just mentioned that's the one that I said that I'm still working with Delegate Teresa and.
Oh, okay, sorry.
Amendments, and if we bring it back, there's an amendment to change the fee schedule to make it a little bit simpler. And I think we may need to change it to make it simpler. So that I think that would help make sure that that we have everybody either on board or understanding that it's not offensive to the conscience. Okay. Let's talk about 405, and that should be our last bill that we need to talk about. 405, Andrew, by the way, are you keeping an eye on the Senate for me by any chance?
I am. Looks like they haven't even started, so.
Okay. All right. Oh, look. Delegate Teresa just sent me something we're working on that. Okay. All right. Okay. 405 is a bill that allows for or requires the court to grant both attorney's fees and expert witness fees to a prevailing plaintiff against a school system in a suit dealing with disability disability programs access. Is that fair to say? Programs to disability for children with disabilities. We spoke about this last time, and there was an issue with the Supreme Court stating that that there with IDEA, which I believe is the technical term for individual disability education access, I think is that the acronym? That you're not permitted to require expert witness fees to be assessed. My proposal on this is, I believe, and I think this would be, and I've spoken with the chairman about this, is that if you can't require it, you can at least give it to the discretion of the judge. And so what I was proposing, and I want to just put this up for discussion, is that we change the law to give the judge discretion to issue both attorney's fees and expert witness fees to the prevailing party if the prevailing party is the guardian of the child, or the parent of the guardian of the child. Is there any discussion anybody wants to have on that? And how does that sound? Yes, Delegate Watson.
So Mike, make sure I understand. So a parent who has an issue with the school system related to placement or IEPs or those types of things has the option to call in an expert witness, correct?
Right, and this would be in a lawsuit. So they file a lawsuit because they refuse to offer them the services they believe they deserve.
Correct.
Rightfully get. So they file a lawsuit. That lawsuit costs a tremendous amount of money for the attorney, and then you have to bring in an expert witness and pay them $300 an hour or whatever it is.
So the parent can bring in an expert witness.
Right.
Okay, I thought I heard you say that you were going to leave it to the discretion of the judge whether to have an expert witness there. And if the
Right.
parent loses, then the cost of that expert witness is borne by the parent.
So Delegate Malone or Delegate Williams, if you want to try and explain it better than I can, because maybe I'm not doing as, but yeah, so no. So the way it works in trial is I'm the attorney for the parent. And I say to the parent, I really want to bring this person because they're going to be very persuasive. This doctor who's going to say this student should have X, Y, and Z services, and they're required to provide them based on my diagnosis, et cetera, et cetera, et cetera. I then charge the parent $10,000 to come in and testify. And the parent then wins the case. The question is, can the parent then go to say to the school system, you should have provided it to me, you didn't, you made me file a lawsuit, I then won the lawsuit, now you have to pay me my $10,000 back that I had to pay the expert witness. That's basically and then what I'm suggesting is that the language as it came in was that the judge shall award expert witness fees. And what I'm suggesting is we change it to the judge may award expert witness fees. And so it will be up to the lawyer to then say to the judge, we believe based on the outcome of this case and it's appropriate for you to award them, and we're asking for expert witness fees. And it would be up to the judge to say, nah, I don't really think you deserve it, or yes, you do deserve it. So
Delegate Cardin, Andrew, can you just bring this one up for me? House Bill 405 in the General Assembly.
Yes.
I just want to point out the language that's in the bill right now to see exactly how you want to change that, because right now there is a may. So I just want to clarify
Okay.
exactly what we want to do. Thank you, Andrew. It's going to be at the very bottom of the bill.
Here, if you want to give me the ability to share, I can also do it.
Oh, is it not? Is it up there?
No, it's not. It just has the Zoom.
Weird.
That's
Okay,
all we can see.
hold on 1 second. I can do that again.
Perfect. Thank you. Okay,
Okay.
so that's what's there now, Delegate Carr.
So where are we? So the court.
Number 3.
Okay. As an award of attorney's fees and related costs, including expert witness fees and costs, may be made to the parent who is prevailing party and who was substantially justified in rejecting a settlement offer. Okay, so it already is a may, it's not a required.
Yes.
Okay, so where did we get the required language from? Did I pull that out of the air? Or is that's what Delegate Lopez, I thought, had indicated?
I think generally expert witness fees aren't the issue was there are only a couple states that do provide expert witness fees. So attorney's fees is usually discretionary, but not expert witness fees. So that was the issue that came up, whether or not those expert witness fees could be awarded, and would that cause more cases to be brought if they could be reimbursed. And I think that was where it all kind of originated.
And is this going to be more onerous? And then I'll get to you guys in a second. This will be more onerous on the school systems that try and provide more programs for children with disabilities, because they're the ones who are going to get more lawsuits against them. So it's the trying harder, the ones that are going to be disproportionately impacted on potential fiscal implications. Delegate Williams first.
No, I guess I don't really have a question. I guess it's sort of been answered. I was just wondering if we had changed it to a May, but I guess that's kind of a moot point now since it's already May.
Well, it says
violation of the federal law, because I thought that was the concern. Does this violate the federal statute by the awarding of the expert witness fees?
So if you go up to L, line 10 in the last page, says the court may award reasonable attorney's fees and related costs, including expert witness fees and costs to the parent of a child with a disability who is the prevailing party in accordance with the subsection. Right, so it says that already up there, and then it says it again. Why does it say it twice? Why does it say it both in L1 and L2? I'm sorry, L1 and L3. Attorney's fees may not be awarded. Can somebody help me?
I'm looking at it now.
So L1 says the court may award reasonable attorney's fees and expert witness fees.
It looks like
the difference. Oh, go ahead, Holly.
Well, I was just going to say, it looks like paragraph 2 is relating to the settlement offer. So it's just clarifying that if they've been rejected in a settlement offer, if they've rejected, substantially justified in rejecting a settlement offer, I think it's clarifying. So I think it's 1, 2, subject to paragraph.
Oh, I see. So number 3 is really only for if they've rejected and substantially justified in rejecting the offer. Okay, and so Delegate Williams, is there a concern about how a judge defines substantially justified?
Yeah, I was just going to say, how do you prove that? And then 2, I feel like Delegate Malone might have brought this up previously. Typically, settlement offers are not disclosed in court. So I think that's the other concern that was raised about this. But yeah, those are my 2 questions / concerns.
So settlement offers are generally not disclosed in court. So you have to disclose the settlement offer, which will then could prejudice the judge.
Right.
Okay. Delegate
That's the only
Watson.
way I could see you could prove it was substantially justified in rejecting the settlement.
Andrew, you can take off the language. Great, thanks. Delegate Watson, did you have a comment or question?
Yeah, once again, I think I'm almost there, but let me just go back through it in my mind. I can't find an instance where a parent has asked for reasonable accommodations to do something for a child. The school denies them. They take them to court, enlist the services of an expert witness, prevail, and why they should not automatically be awarded expert fees. And so I'm questioning whether or not that may should be a shall.
Right. So and that's a great question. I think that you can't make it a shall because there's a Supreme Court case that says that you can't.
That's the problem.
That's the problem.
But they're not
Yeah,
asking
the
for it to,
Alito opinion. Yeah.
right. They're not
That's the
asking
one
for it to be
Delegate
shall.
Watson I sent to you last meeting. I can forward it again.
And I think I think that's why Delegate Lopez's bill only has the may. I was under the impression it had the shall,
Okay,
and at least for when you prevail, and there's no settlement offer issue. That's
I understand. Okay,
I was wrong about that. Okay. So really the question we have, so Delegate Williams, did you have another comment about?
No.
Okay. So really the question then, and Delegate Malone, yes, Delegate Malone.
Well, I still have a problem with it as it's written regarding this option about settlement proposal, because I don't think it clarifies how the proceeding is going to go. And the only way I know you can do the proceeding fairly would be for sure that there's some type of bifurcated trial. And I think you'd have to have language that lays all that out. And I'm not sure how to do that, because as you said earlier, if you disclose the settlement offer, it could prejudice the judge. And the reason to put it prejudice the judge, once the judge knows, hey, you were willing to do this, why not I just go ahead and award this? Well, you may have been willing to do this because you're willing to, that's what you're willing to do to settle the case and avoid litigation, but that's not what you would be willing to do if you actually went to trial.
Right.
And I think the bill as drafted is problematic. And
So
we can't support it.
Is it possible to, yeah.
I mean, this is just a thought, Delegate Cardin, and I, again, this is a joint bill, so we'd have to maybe look into it. But what if the settlement language was removed? What if it was just the prevailing party? You know, shall get the, or may get the, why is that? I'm just curious. I don't know the background enough in this. Again, we're secondary in this one.
Right.
But why
Here's-
is that settlement language in 2 and 3?
So I am, so the problem with the language in 2 is that when they offer them a settlement of $1,000 for something that costs $100,000. And so it's not a legitimate settlement, but they can say, well, we offered them a settlement, therefore they are, that's the problem with number 2, I think. Right? Because it doesn't say that has to be a justified settlement within 14 days. It just says it has to be a settlement, I think. Number 2, if the settlement offer is made 14 days, settlement offer is not accepted, the court finds that the relief finally obtained by the parent is not more favorable to the parent than the settlement offer. Okay, so that does. So yeah, so I guess that. But the question that Delegate Malone does bring up is that you can't bias a judge by talking about settlement offers. You just can't. I mean, I've tried to, by the way, and the judge won't let me. Judge, I've offered him the, you know how much they've offered me or something like that? Judge, don't.
I mean, I know we're pressing against time. I wonder if there's a compelling reason why that language is in there. And if not, would the sponsor be okay with us just striking sections 2 and sections 3?
Right, but what if they offered him $50,000? They offered him not 80% of what they wanted. They rejected it because they wanted 100%. Or they offered him 90% of what they wanted and they rejected
Then
it.
they go to court.
Right, but then if they prevail, in court because they didn't get it, should they be denied the ability to get expert witness fees based on the policy that they're trying to do here, which is, we offered them a justifiable settlement package, so therefore we shouldn't be required to pay the expert witness fees because they did agree.
But they won't be required. It's a may. So the court can make that determination. Yes, this case is justified in awarding the expert witness fees. No, this case is not justified. If the judge would have the discretion to make that determination.
Well, that would be, but then, okay, so then the language should say something to the effect of, after the trial, after the determination of the trial, the judge can utilize the settlement information that happened preceding the trial to determine.
But why
whether
would
the
we
fees-
still bring in the settlement information? And I guess that's my question. Why is it a necessity to bring
Because the
settlement
judge needs to
information?
know that should be, I think the judge needs to know that should be an aspect of his determination of whether to award the expert.
We don't do that in any other case. That's why I'm asking if if there's a special reason why we should do this in these types of situations. And I just don't know enough about these types of cases to say that it's a necessity. I guess that's my concern.
I wonder why has it been in the bill and for the last 2 years if it's not an important part? You're just saying, you think it's in there to make it just an easier bill to swallow? I mean, why would it be in the?
And my concern is if we now try to pass it without that paragraph, and I have this problem with other bills too, I think it substantially changes the bill. And I don't think it's fair to the advocates and organizations that came forward or might have come forward, as long as that language is in there. Because there's a lot of, school systems that may say, well, we always make offers. We always try to resolve this. So we're fine with this bill. But if we take it out, now they may not be fine with it. And
Right.
And how are we going to know? Who's going to take the time to reach out to the 24 different schools?
What if you said something to the effect of the court shall use information may be awarded to a parent who is the prevailing party and who provides information to the judge after his decision that justified rejecting a settlement offer.
But John, that doesn't address what I just raised. I mean, who's going to contact the 24 different school jurisdictions and give them sufficient time? But
it's essentially what I'm suggesting is we just clean the language up so that this doesn't come in as part of the trial. It only comes in after in determining the fees.
But if I was a superintendent of schools, I may have been fine with this bill just as it is, but not fine with what you just proposed.
Well, I think that what I'm proposing, though, is not substantially changing it. I think it's just clarifying what the judge is allowed to do. I think that actually, the more I think about it, the judge is never going to know about it until it comes time to award the fees. So therefore, it wouldn't come out during trial. So the judge wouldn't. He will award. He'll make the decision on whether you get the services that they're claiming, and then at the end, we could just add a sentence that determination of fees and costs shall be made after the.
Yeah, I think I'm okay with that. If there's a separate hearing on the attorney's fees and costs after the judgment's been rendered.
So that a separate hearing shall take place after a judgment's been rendered to calculate and determine fees and costs to be awarded to the prevailing plaintiff.
Delegate, I have to go prep because we're headed to the next. Do we want to just hold on to this and maybe work out the language? I'd also like to talk to the other committee and just get a little bit more background in this.
Okay. Is there a motion to hold?
So moved.
You have unlimited holds.
Unlimited hold.
So moved.
And we may bring this one back. We may be bringing 213 to us, and we may be bringing 766. I think that's all we have left.
Malone,
Yes.
Cardin stands for can do anything. That's what that means.
Quick question, Mr. Chair. I'm sorry.
Wait a minute, Nicole. Wait a minute. Yes, Delegate Conway.
How you doing? Do we have committee today?
We're going to be voting later
At what-
this evening.
What time?
Probably after the floor, so probably around 7 or 8 tonight.
Okay,
It's going to be a long
thank you.
night, so
Thank you. After the floor. Thank you.
Okay. Yes, Delegate Williams.
I just was trying to get the bill numbers of the other bills that you said you want.
766, maybe 213, and maybe 405. Those are the three bills that we have left.
Okay, 4 or 5.
Unless anything else, unless the chair throws something our way.
Okay, thank you.
Thank you. Thanks to Holly. Thank you,
Thank
Andrew.
you.
Okay. This concludes our civil law